For a delivery driver, a DUI is not just a legal problem. It is a direct threat to your paycheck. Gig platforms run background and driving record checks, and a DUI can flag your account for review or deactivation before your court case is even close to resolved. Understanding that your platform account and your criminal case move on separate timelines is the first thing you need to grasp. A DUI hurts your delivery work regardless of when it happened. An arrest during an active shift raises immediate complications with the platform and the order in progress. An off-duty arrest can still surface during a periodic record review. Because your personal driving record is directly tied to your gig income, there is no such thing as a purely private DUI when your car is your job. Gig platforms collect a surprising amount of data, including your location, trip history, and timing. If your arrest happened during a shift, that data becomes part of the picture. It can be used against you to establish you were working and driving at that time. But it can also work in your favor, for example by supporting your account of where you were or what you were doing. Knowing what was recorded and who can access it is an important part of evaluating your case. For a delivery driver, protecting the license is the single most urgent practical step. After a DUI arrest in California, you generally have 10 calendar days to request a DMV administrative hearing, or you lose the right to contest the automatic suspension. On a first offense, many drivers can keep driving by choosing an ignition interlock device for roughly 6 months, which allows full driving privileges. Alternatively, a restricted license without an interlock limits you to work and DUI program driving. Either way, acting fast on the DMV side is what keeps your income alive while the court case plays out. Here is one piece of good news. Most food delivery drivers use their personal vehicles on a standard license, not a commercial driver's license, or CDL. That means the harsher CDL disqualification rules that apply to truck and bus drivers generally do not apply to you. The standard DUI consequences are serious enough on their own, but you are not in the commercial license category, and that distinction matters for how your case is approached. Because your platform standing and your insurance both depend on your driving record, the difference between a DUI conviction and a reduced charge is not abstract for a delivery driver. It can be the difference between keeping your income and losing it. All the standard defenses still apply. Whether the stop was lawful, whether the chemical test followed the proper procedures under California's Title 17 regulations, whether the timing of your blood alcohol level was accurately calculated, and whether the field sobriety tests were fairly conducted. Results vary and there is no promised result, but fighting for the best possible outcome is more important for you, not less, precisely because your livelihood depends on it. For a delivery driver, your car really is your paycheck, and the steps you take in the first 10 days after an arrest can shape everything that follows. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.